I guess my law clerk was just telling me that he got a message from Mr. Klusak a couple days ago trying to explain things. That's just what he told me. I know nothing about it. This is Singh and Mars Party Store LLC versus Klusak Construction Company LLC et al. Docket number 20-238CB. This is the plaintiff's motion for entry of default judgment. I'll take the attorney's appearances, please.
Good afternoon, Your Honor. Brian Leck on behalf of Ranjit Singh and Mars Party Store.
And good afternoon, Your Honor. Craig Thompson on behalf of defendant Russell Peabody and Russell Peabody Architects, PC.
Great, thank you. Mr. Lick, you can go ahead.
Thank you, Your Honor. This dispute arises out of defendant's defective construction of plaintiff's commercial property buildings located on South Martin Luther King Boulevard in Lansing. The parties entered into a contract in September of 2018 to build these buildings for payment of approximately $392,000. The defendants, Adam Klusak and Klusak Construction, were responsible for building according to the plans and specifications and the building codes. However, in January of 2020, January 27th of 2020, the buildings collapsed. The roofs, trusses collapsed and the walls collapsed. And the city of Lansing ordered that the buildings be demolished. Klusak Construction and Adam Klusak failed to cure the defective construction. They failed to rebuild. They abandoned the project. They didn't return any of the trust funds that had been paid to them. At the time, they had been paid $229,000 out of the $392,000 contract amount with very little work actually done. My clients incurred substantial costs, will incur substantial damages, including the cost to rebuild, the cost to the delay damages, the lost profits, court costs, interest, attorney fees, and expert fees arising out of this dispute. We filed our complaint on April 28th of 2020. The defendants, Klusak Construction and Adam Klusak, were served by alternate service on August 6th and August 15th by regular mail and tacking. On September 24th, the court entered a default against defendants Adam Klusak and Klusak Construction. They were served with that default on September 28th. They were served with a copy of this motion. Because of the default and their failure to proceed or defend in this case, all of the allegations in the complaint are deemed admitted. The defendants have breached the contract, they've breached the warranty, they have violated the Michigan Building Contract Fund Act, they have failed to account for or return any of the trust funds paid to them, and they have converted the trust funds for their own use and benefit. I have reached out to Mr. Klusak on several occasions throughout this past year without any success. I have called, I have written, I have emailed, and I have not received any response from Mr. Klusak. Because of his failure to participate in this case, all the requirements for the entry of the default judgment have been met. And so for those reasons, I ask that the court enter default judgment against Adam Klusak and Klusak Construction in the amount of $714,309.49 in the form attached as Exhibit D to the motion. And does the court have any questions about the motion or the order?
I do have one.
Yes.
I believe you're entitled to treble damages, and this question will pale in comparison, but how do you get expert fees? I didn't understand that.
The expert fees, because of the costs that were involved with having to discover what happened here, the expert fees are, I think, costs under the prevailing party court rules.
Okay, yeah, I just thought there were limitations on that, but it sounds like maybe it's more a part of the actual damages rather than the costs that are incurred, which are limited, I think, on expert fees, but in any event, I.
Exactly,
have
Your Honor.
reviewed
These are
what-
damages that arise out of the breach of contract.
Yeah, I get that now. That's what I was not clear on, because I think you're limited if they're, you know, like litigation expert fees, but this sounds like it's more the direct damages in order to, you know, deal with the situation of the collapse. So I think you are entitled to a default judgment as you have requested, and I am signing your judgment right now, as you indicated with, or as I've indicated with treble damages and the other damages as you've explained to the court. And it is the 3rd of February, and I have signed it. So
Thank you, Your
I
Honor.
can take care of having that filed and sent out.
Thank you very much.
You're welcome.
Thank you, Your Honor.
Okay, thanks.